In this video, we're talking about conflicts of interest, and specifically whether one lawyer or one defense law firm like ours can represent two different people, so two separate individuals also charged with crimes. They may be from the same incident, they may be from separate incidents. And the short answer as to whether or not that's a good idea is that no, it's not really a good idea to represent two people, because there's an inherent possibility that one person may take some advantage of the other person, or that the law firm or the attorney can use information by one person against the other person. And so you just want to make sure that there's no conflict of interest. The firm, the lawyer, owes the same duties, the same responsibilities, the same rights, the same level of representation to both individuals. And so when you have two of them, there's a possibility that one person may be favored or one be benefited against the other. So it's called a conflict of interest. Generally, it's not a good idea to represent two people, but you can do it. You can do it in a situation where both of these people have interests that are aligned, and they both have informed, and there's written consent that they know that this is happening. In other words, they are agreeing and they are allowing the law firm to do that. They're saying, we understand there is a potential for a conflict here. That being said, we're going to acknowledge that. We're going to waive any problems with that, and we're going to allow the firm or the lawyer to represent us both. And there may be situations where that's to their benefit. That's to both of their benefits. So let's take a quick example. Let's say that in a hypothetical situation, there's this delicious candy bar and it was stolen. The police come around, they're investigating who stole the candy bar, and now they're looking at A and B. They pull them aside, they question A and B, and they say, we believe that you both stole this candy bar, and so we're going to charge you both with a crime. So now A and B, they come to our law firm and they say, hey, look, we were both charged with a crime. We want the best representation. We want the best criminal defense lawyers. So naturally, we came to the R&R Law Group, and we need help with this. We say, look, we can only represent one of you because there is a possibility that the government may want one of you to go against the other one. Therefore, we think there's a conflict of interest. We can't represent you. Well, if both A and B say, we understand that there is a potential for a conflict, but we are 100% certain, we're 100% in alignment. We did not do this. I did not do it as A. B, I did not do it as B. There's no reason why there's going to be us pointing our fingers at one another. In that case, if they sign some informed consent and we all agree to it and it seems like it's a good fit and the facts of the case are reviewed by our attorneys and we decide this is something we want to engage in, we can decide we'll move forward and we'll represent them both. The downside to this would be if at a later time, A and B, they get plea offers, or the prosecutor comes to our office and they say, well, we'll give B a deal so long as A takes the fall for this thing. So if B agrees that he's going to testify against A and B is going to get a good deal, now our firm, as the defense attorneys, we have to get off both cases. We now know that there's a conflict that has been developed, and so we have to get off both cases. So that's where it becomes kind of an issue for defense lawyers. If you know or foresee that that is going to be a possibility, you want to make sure that you're not even going down that road. But in the event that the government comes and they offer B a plea deal, and we can say B says 100%, did not do it, I'm not taking any deal, and they're going to be in full alignment and there's not going to be any conflicts there because their interests are aligned. Both A and B are saying that C did it. Their interests are not going to be conflicting with one another. That representation might be okay. But if that perceived conflict, if there is a conflict, if there's any whatsoever, any potential of A and B pointing their fingers at one another and not pointing it towards C, that attorney is going to have to get off both cases, and both attorneys are going, or both individuals, both A and B, are then going to have to go and get their own separate counsel. So it's not something that we do frequently, but sometimes the interests are aligned. It may be beneficial to have one attorney on both cases if both A and B are saying, look, we both have evidence and we know that C did it. We know that this happened, and here's why, here's the evidence. We want to work together on this thing because we are being wrongfully accused, we're being wrongfully convicted, or simply they don't know who did it, but it wasn't either one of them. There may be some strength there. But the government will see that, and what they're going to try to do is create that conflict or force one to go against the other one. So this is a simple candy bar case, okay? In reality, these can be very complicated. There can be multiple different levels of conflicts. There can be multiple other parties. You can draw out the entire alphabet in big complicated cases that are involving multiple defendants. But generally, this is the principle. it's usually a good idea to have your own attorney, but there are some situations where both people's interests are aligned and the likelihood of a conflict is just not going to come up due to the facts, due to the criminal charges and those types of things. So if this applies to you, I hope this helps. If you want to speak with our office, we offer free case evaluations. We're happy to sit down with you and talk it through. Thanks for watching.